Chip said, I'm very happy to be here. I am all about dialogue. If you know me from LinkedIn, which I'm amazed how many people do now, I am about dialogue. I want to have a discussion. I always think discussion is good. So today, we're going to have a lengthy discussion about some really big issues. And I ask two things. First, the room asks that if you have a question during the presentation today, to come to one of the microphones. You'll see the two microphones here. Come on up. Brian and I will see you standing there. We'll know you have something to say, and we'll acknowledge you, and we welcome your questions. Number two, I use that word carefully. We welcome your questions. Okay, so whatever you say, please try to end with a question mark. Okay, because if you give me a 6-minute rant about an Allstate claim in Topeka, I can't help you. Okay, I don't care about your Allstate claim in Topeka. All right, but if you have an issue about something of industry importance or a general issue, I welcome it. All right, I don't represent Allstate, State Farm, USAA, or Farmers. Okay, those are not my clients, so I can't solve those problems for you. And I'm sympathetic to those problems. I'm hearing a lot about issues there, and I'd love to talk later about some of those. But in any event, we welcome your discussion today through the issues. All right, so today let's start with, no, I don't want to talk about GCOMP. All right, that's too boring. Brian, you want to talk about wind versus water?
No.
No, God, no. Let's not talk about that. Should we talk about code upgrade? No, these are all just the garden variety crap that I'm tired of talking about, right? Should we talk about our dense damage? All right, well, if you live in Texas, that's the only goddamn thing we talk about anymore, right? Yeah, our dense damage. And lastly, should we talk about whether all insurance company lawyers suck? All right. No, let's not talk about that today, should we, Brian? All right, but what we should talk about are some big issue problems, the big things that are driving the dialogue and the future of our industry, right? Both of us on both sides of all this. So today we're going to focus on the state of the industry, the big issues, what's going on, and with that, we're going to begin with a couple of opening statements. First, Brian will talk for a few minutes about what he believes is happening, what's important, and then I'll do the same. Brian?
Thank you, Steve. It's great to see everybody. Just before I get into the policyholder perspective as an intro here, I'm probably one of the few people that has spoken at this seminar every year since it started. So this is probably my 12th or 13th straight year. And I, too, remember the meeting with Chip and others and Steve Figlin formulating this meeting. And it is amazing to me to see how this meeting has grown. And credit to Steve Figlin, certainly, now Brian Evans, to George and his staff for doing such a great job. Additionally, I told Steve Badger yesterday, we got together to kind of work through the final touches of this, and I said, I give it 15 minutes tomorrow from the time we start till there's some social media post demonizing me for being on a dais with him. There you go. So I think that it's, frankly, a testament to Steve and a credit to him to be here. I think that the more we do have a dialogue about all these problems and differences, the better. And I think that civil discourse is always preferable to, pardon the analogy before this crowd, to burning down the house, as a way to try to make things better. So Steve said in the introduction, what, from the policyholder perspective and frankly from the public adjusting perspective, what are the big issue problems impacting our industry? And for me, I wrote down 4 that I just want to give a broad overview, and we're going to get into these in some greater detail a bit later. But these are the 4 problems. First of all, there's an emergency going on in 2 areas relating to first-party property claims, particularly from a policyholder perspective. One is the anti-public adjuster endorsement in the policies. Now, I know that everybody who are members of NAPIA know about this, but are there people in the audience who don't know what I'm talking about, or do you all know what I'm talking about? Raise your hand if you know what the anti-public adjuster endorsement is. Okay, so there's a few hands that aren't raised. So for those of you who don't know, insurance companies now, and to my knowledge, these are all surplus lines carriers, which, by the way, have no accountability or they do not come under the plenary power of any state insurance department. But they're putting clauses in their insurance policies that say to a company or an individual, Mr. So-and-so, we will insure you, but you agree as a condition to letting us insure you, you will never, ever have the right to hire a public adjuster. And we started seeing this in certain carriers' policies about 3 or 4 years ago. But at that time, these things were snuck into the policies. And again, if you're a domestic carrier, you come under the plenary power of the insurance department of each state, and state has to approve all your endorsements. A surplus lines carrier doesn't have to do that. So these carriers weren't really enforcing this, but now they are. And now public adjusters are losing out on the ability to help insureds because of this endorsement. And frankly, if it spreads, this, and this is not an overstatement, this could end the public adjusting industry as we know it. So NAPIA is all over this. We're on it. We've got a lot of different things we're considering as to how to deal with this. But it is a major, major problem, and it is the biggest threat to the industry, in my opinion, since 2008, when we started to see the advent of the unauthorized practice of public adjusting, which I will get to in a minute. Texas passed a law earlier this year where the Texas legislature said, this is illegal, you can't do it. That was great. Same law was teed up in Louisiana, and at the 11th hour in Louisiana, the lobbyists for the surplus lines carriers came in, scared the living hell out of the insurance department and the legislators and said, if you don't give us an exception for this, meaning this law doesn't apply to us, we're going to pull out of the state and nobody will get insurance, particularly businesses and individuals who are susceptible to natural disasters. So, of course, the legislature caved, and Louisiana passed the same law as Texas with one big exception. That is that this law does not apply to the surplus lines carriers. Well, in my business, the law business, that's what we call a distinction without a difference, because the surplus lines carriers are the only ones who are doing this. So it's a real problem, and that is one of the things that we're talking about, big picture issues. That's something that is a big, big problem to the insureds. Appraisal. There is a crisis in appraisal. We've all been involved in appraisals. We've all dealt with them. I've been an appraiser in numerous cases. I'm sure most people here have. And appraisal, I grew up in the industry. My grandfather was a public adjuster. My father was a public adjuster. My brother's a public adjuster. I'm like Al Pacino in The Third Godfather. Just when I think I'm out, they pull me back in. I'm the only one that didn't become a public adjuster. But appraisal, and I don't want to get into any political, I'm using this statement as an analogy, but appraisal, when I was growing up, both personally and professionally in the business, was what President Clinton and Hillary Clinton used to say about abortion. Appraisal should be safe, legal, and rare. And now it is no longer rare. Appraisal has become a cottage industry. It's being done all the time. It was not designed for that, and the system really can't handle it. One of the reasons for that is that back in the day, adjusters for both sides used to really try to adjust claims. And that is no longer happening. Carriers, and Steve is going to probably jump at me on this, but carriers are now sending in drones. They're using adjusters who are in their 20s and 30s who've never really seen a property loss, don't know what they're doing. Public adjusters don't have the requisite, oftentimes, knowledge and training to handle certain types of losses. And so the easy thing to do is throw everything right into appraisal. And that is not what the appraisal clause was designed to do. As a result of that, we see things like, and we'll get to this later, but people like Steve, and I don't, when I say people like Steve, I don't mean that in a pejorative way, but they're trying to come up with new approaches to appraisal to pull it back. And I understand the reason for that. So there's an appraisal crisis in the first-party property industry that we have to deal with. And this is fostered by, and my third big picture, big issue crisis thing is UPPA. I mentioned that this anti-public adjuster endorsement is the biggest threat since 2008. 2008 is when we started to see the advent of UPPA. What is UPPA? The unauthorized practice of public adjusting. So what happens in UPPA? Contractors, roofers, unlicensed individuals try to function as licensed public adjusters. And one of the things that they do when they sign people up is they throw things right into appraisal. And the system can't handle that, and it's wrong. We're making great progress in the UPPA area. We'll get into that later. But that is, so those to me, from the policyholder perspective, are the three biggest issues that we have to deal with when we look at the big issues affecting the industry. And before I turn this over to Steve to get his perspective on what he thinks are the big issues, I do like the fact that he's down on the ground and I'm up here because I am now not shorter than you are. So this works out well for me. Anyway, that's my intro.
Perfect. Thank you, Brian. Brian gave you a great intro to a lot of the things we are going to talk about at length today as we move forward, so I appreciate that. All right, my turn. I'm going to give you the insurance company perspective now. So, in my view, as to what's happening in the industry right now, for all of us, we are in a period of dramatic change. Right? The big issue is the change that's happening in this industry right now. And the change is coming from several places, one of which I look at the agenda for today, and there's a lot of discussion about emerging technologies, artificial intelligence. Yeah, that's happening in the industry. But what's driving that more than anything is climate risk. Climate risk is changing the insurance industry. The insurance industry is realizing with increased climate risk, the traditional model where 100 people pay premiums and one person has a loss, right, that doesn't work anymore. It's strained when 10 people have the loss, and it's unworkable when 50 people have that loss. And that's the problem we're facing, is that so many people are having the same loss. Severity is up, frequency is up, that it's straining the system. And as a result of that, because my clients are for-profit companies, and we have to remember that. My clients are for-profit companies. They are not benevolent societies. Yes, they should pay every claim fully, fairly, and promptly. I think that will probably show up in Chip's blog tomorrow, won't it, Chip? You getting that down? All right, good. I agree with that. All right, but just because they have a lot of money doesn't mean it's okay to rip them off. All right, it's not okay to go in an Apple store because Apple has a lot of money and steal an iPad. All right, and it's an apt analogy, isn't it? Okay, they are for-profit companies. All right, so when they're pressured from whatever area, and the big pressure right now is climate risk, they are going to react and figure out what to do. One of the things they're doing, yes, is emerging technologies, AI, different issues. Well, Badger, they're sending out drones to adjust claims. Here's what I tell my clients. If you're going to send out a drone or a ladder assist to adjust a claim, you better buy the roof, or you better accept the claim. I'm with you on that. If you're going to deny the claim, you better put boots on the roof. Right? I agree, 100%. But the industry is struggling to try to find some balance in between where they can spend less money, take advantage of emerging technologies to adjust claims, but still satisfy their obligation to adjust the claim properly. And one of the things that's coming, which is a game changer for all of you, because it cuts you out of the business entirely, is parametric insurance. Everybody know what parametric insurance is? For those of you that don't, I'll give you a real simple answer. The amount the insurance company pays has nothing to do with the amount of damage incurred. It is entirely dependent upon the strength of the storm that caused the damage. So 1-inch hail, you get X. 2-inch hail, you get Y. 3-inch hail, you get Z. Same with hurricanes. or whatever the risk is. They can apply it to fire. They can apply it to all different things. Parametric insurance is coming. There's no adjustment. There's no measurement. And where does that put you? Yeah, that's an issue. All right, so these are all things that are happening. The last one that's happening that I'll just preview it, and we'll talk about it later, is preferred contractor, managed repair, invoking the right to repair. That is another issue that's getting a ton of attention right now, and that's a game changer for all of you. So with that, let's jump into it. The first topic we want to talk about are threats to the public adjusting industry. Brian's previewed some of these, but I think it's a really big issue, all right, and we should all pay attention to it. This is how important this is, all right? So let's emphasize it with video and sound, because I truly believe there is an attack on this industry. I get it. I see it every day, all right, from my side. But it's not just my side. Yeah, there is an attack from the insurance industry. Brian's talked about already anti-public adjuster endorsements, right? And I started seeing them a number of years ago. Clients came to me over the past few years and said, Badger, we want to have an anti-public adjuster endorsement. Brian, what do you think I told them?
I'm hoping the answer is you really shouldn't do that.
Actually, what I told them was you absolutely should not do it. Yes, I did. I told my clients that it was wrong. Right, there is a role for the professional, we'll talk about that, public adjuster in the claims process. So I discourage my clients from doing it. And as Brian talked about, when it came up in the Texas legislature that your group Tapia said we're going to push legislation to stop anti-public adjuster endorsements in Texas, what did I do? I supported it, absolutely. So talk a little more about it, Brian, about generally the problems with it and what will happen.
Right. So Steve put up the, highlighted a section, a slide that I gave him, and I'll read it to you. But the typical clause is, it is understood and agreed that a condition of this policy is that the insured shall not hire, engage, retain, contract with, or otherwise utilize the services of a public adjuster, whether or not licensed in the state where the property is located or any other jurisdiction to inspect, evaluate, or adjust any loss covered by the policy. Now, let me just say that number one is to Steve's credit as to what he told his client, and number two, I'm heartened by the fact, even though it's awful what has happened, that like me, like any lawyer, oftentimes you give a client advice and they don't listen to you. So it's good to know that I'm not, whistling in the graveyard, so to speak. And I also give him credit for not opposing it in the Texas legislature. We dealt with this issue for the first time about 15 years ago in Florida, and we filed suit against a company called Sawgrass Mutual, which, ironically enough, we lost the lawsuit, but we lost it on a constitutional issue of standing. The court never reached the merits. The court said we, NAPIA, and FAPIA may have been a named plaintiff too, didn't have standing, we weren't the right party to bring the action. You have to find an insured. Sawgrass Mutual, ironically enough, has gone into receivership and they're out of business. The problem with the anti-public adjuster endorsement, the problems are myriad. And what there's two major kind of tentacles that flow out of this. Number one, what do we do to attack it? All right. Do we try to approach it legislatively? Do we file a lawsuit? And again, do we not have standing to do that? Do we file a lawsuit under a different nomenclature, a different cause of action? Is it not just intentional interference with a contract? Is it something else? Is it antitrust? Are there Federal Trade Commission issues? I mean, it is a very complex issue to deal with. And I tell you, I was making light of the fact that the client didn't listen to Steve. I'm sure that these surplus lines carriers probably have spent millions of dollars having lawyers similar to Steve that work for them research the potential attacks on this clause and how to fight them. And it's very hard for the public adjusting profession to engage in any big battle like this against the insurance industry because we are, dwarfs compared to them in terms of our resources. But we are fighting back. I do believe that this clause is against public policy. I do believe it's illegal. I do believe it's against antitrust. And it would be similar, the analogy I always use, it would be similar to somebody having a health insurance policy. And the health insurance policy says, okay, we will insure you for all your health needs, but if you have an abscessed tooth, you can use anybody to pull that abscessed tooth, but a licensed dentist, who, by the way, is the only person really recognized and licensed by the state to do that kind of work. It's nonsensical. It's trying to, by contract, legislate you all out of business. And the concern now is, what we have found is, Steve was quiet in Texas and the industry was quiet in Texas, but now the slumbering giant has woken up. They came in to Louisiana and they killed it. We've been working up in 2 states in New England. They came into New Hampshire and they killed it. So they're not going to let us legislatively do what happened in Texas. And it is a real problem for the public adjusting industry.
Brian, who is they? Who is showing up in those states and killing that legislation?
Yeah, the lobbyists for the insurance industry, particularly for the surplus lines carriers.
In those states, not the national groups. Is that,
well, I can only speak to where there's been action. Okay, so in Louisiana, bill was introduced, they came in, they killed it. In New Hampshire, a bill was introduced. Here's what happened in New Hampshire. I wrote a letter about this issue to all 50 state attorney generals, and the insurance departments were copied. The letter didn't get a whole lot of traction, but it did draw the attention of the New Hampshire Department of Insurance and the Massachusetts Department of Insurance. They both contacted me. They both introduced bills, like the Texas bill, to forbid this policy. In New Hampshire, the insurance commissioner didn't even know he'd introduced such a bill. But one of his assistants had gotten my letter, so he introduced it. And anyway, when it got to the chair of the committee didn't even know that he had introduced it. We had a conference call with him, and and Chris Aldrich was on that phone with me a month ago. And the lobbyist for the surplus lines carrier had basically convinced this gentleman who's chair of the Commerce Committee in New Hampshire in the House or the Senate, I can't remember which one, to basically, this will go nowhere. He said, this is not a problem in New Hampshire. They said they will never do it here. They will never issue a policy like this here. P.S., they have issued policies like that in New Hampshire, and I showed it. It didn't matter. They killed the bill.
And in my view, that's unfortunate. Hopefully, moving forward, the Texas experience will carry the day in other states, because I do know the large national trade groups stayed out of the dialogue in Texas, and I would have thought they'd done the same there. So it sounds like this is being driven on a statewide level, and that's harder. All right. We've talked about how you're under attack by state legislatures in the area of anti-public adjuster endorsements. You've got licensing in 46 of 50 states, the public adjuster licensing statutes. We'll talk a little bit about that today. But there's a number of other areas where you're under attack with what state legislatures are doing in some areas. You want to talk about those briefly?
Some of the hot button issues where statutes are attacking public adjusters. Let me jump to the second one first, because that has gotten a lot of play and a lot of news, and that is fee caps. 46 of the 50 states license public adjusters. The only 4 that don't are Alabama, Arkansas, Alaska, and South Dakota. In Alaska and South Dakota, they let you work. You're just not regulated. In Arkansas and Alabama, you run the risk of being arrested if you are practicing public adjusting. In 2005, we were very influential and worked very hard with the National Association of Insurance Commissioners to have a model bill passed. The model bill was passed in 2005 and is silent on fee caps. The model bill is now being reopened, essentially to deal with issues of fraud, with issues of unauthorized practice of public adjusting. The legislature, the legislators, and the regulators who are involved with NAIC have made it clear they want to put fee caps in the new model bill. That's the bad news. The good news is the fee caps will be 15% on regular claims and 10% on declared catastrophes. In our comments to this NAIC new model bill, we wrote a 3-4-page letter in which we argued for 3 paragraphs to leave fee cap issues to the states, let each, just like the current model does. At the end of those 3 paragraphs, we then wrote, having said all that, we will not oppose the fee caps. We're just not going to support them. Well, somehow that got turned into a social media war that somehow NAPIA went into the NAIC and advocated for fee caps for public adjusters. Nothing could be further from the truth. That was never done. Our position is constant, is clear, has always been. We will never advocate for or openly support fee caps, but if regulators and legislators come to us and say, we're going to have fee caps, we will work with them to make sure that they're fair and reasonable. An example of this is post-Katrina, when we got licensing in Mississippi. They wanted a 7% fee cap. And I was down in Mississippi. I spent 3-4 months between Mississippi and Louisiana getting licensing done. And basically we said, 7% fee cap is not going to work because people can't make a living. There's too much to be done. We got that raised to 10%. And P.S., there's never been a real problem in Mississippi that has ever been brought to my attention with regard to our fees. So additionally, in terms of what was out there, it was also published online that somehow we supported that the fee caps apply to our fees on new money only, not on money that had been offered before we were retained. That's not mentioned anywhere in the new model bill. It's not mentioned anywhere in the current model bill, and it certainly wasn't mentioned anywhere in any of our comments. There's a lot of misinformation. Social media and the internet is a great thing. It's also a dangerous thing because there's a lot of misinformation out there. But in terms of statutory threats to the profession, fee caps are here. They're here to stay. Of the 46 states that license, only 13, I believe it's 13, it's 11 or 13, have statutory fee caps. I think you're going to see more of those, and we will continue to work with legislators, and regulators to make sure that those fee caps, if enacted, are fair and reasonable. Solicitation is a big issue. And, you know, a lot of these issues I'm talking about today kind of bleed into one another. Solicitation is a problem because many states have hour restrictions on solicitation. The model bill's definition, and it remains it in the new drafted model, is that solicitation it cannot occur during the loss-producing event. Some states go 8 p.m. to 6 a.m., blah, blah. But none of those rules apply to contractors. None of those rules apply to roofers. None of those rules apply to salvage companies. So it puts you guys somewhat behind the 8 ball, you guys who are public adjusters. The rules do apply to lawyers. Lawyers cannot solicit at all for business.
Let me pause there because I hear this a lot from lawyers, Texas policyholder attorneys, who some don't feel as favorably about public adjusters as others. And they complain to me all the time, Badger, why are your industry and the legislature in Texas allowing public adjusters who are essentially acting as lawyers, you're advocates for policyholders, why are you allowing them to solicit in a way that lawyers are not allowed to solicit? And that's a legitimate concern.
Right. Yeah. Rescission. Rescission is in the model bill. I believe it's in every state statute. There's a right of rescission. It goes anywhere from 3 days is the standard one. That's what's in the model. And I believe that's in the 3 days is in the great majority of the states that license. But some states go as high as 5 days. And I think there's one state, Jeff Gould will tell me if I'm right about this, there's one state where the right of rescission is like a 10-day period or something. Right. Let me give you all a little bit of some free legal advice, which, of course, as my torts professor in law school said, remember, if a client ever asks you for free legal advice, tell him or her that it's worth exactly what you pay for it. But I'm going to give it to you anyway. If you lose a contract within the rescission period, and I know sometimes that there, maybe competitors of yours go in and get it, don't file a lawsuit over it. You're not going to win. you're going to lose. You're going to probably guarantee that you get countersued, and it's just not worth it. But those are, these are the major things we're seeing statutorily that are trying to restrict your ability to work, or at least control your ability to work.
You are under attack from roofing contractors, more so than anyone else. Right now, there is a case in Texas, the Stonewater case. And if you're not familiar with it, you should read about it. It is now presently pending before the Texas Supreme Court. And what this contractor is asking the Texas Supreme Court to hold, that is Chapter 4102 of the Insurance Code, which is your licensing statute. That statute is an unconstitutional restraint on the contractor's right to free speech. And if they win, and they actually won preliminarily in a lower court, but if they win on this issue, your public adjuster licensing statute is gone. Poof, it's gone. Anyone can act as a public adjuster. Anyone. And think about how scary that is. And I think it's pretty scary. So I, on behalf of the insurance industry trade groups, APCIA, NAMIC, and the Insurance Council of Texas, we filed an amicus brief in support of you. We supported the role of the public adjuster in the process and pointed out all hell that's going to break loose if we eliminate your right as the exclusive provider of public adjusting services in my state. Yeah. And your organization came in with a letter as well. You partnered with the Coalition Against Insurance Fraud and came in also. And I must give Chip credit. Chip even blogged about this unprecedented move where Badger and his trade groups actually said something nice in a brief in support of this industry. But this, in my view, is the biggest threat to you, because if they prevail on this issue, Katie barred the door. It's all going to change. So I'm really hopeful the Texas Supreme Court gets this right. And we're expecting a ruling any week now. Any Monday at 9 a.m., we will check and see what's going to happen on this
Steve,
difficult issue.
Could I jump in on that issue? Okay, so the Stonewater case, I want to talk a little bit about it. First of all, Texas, of all states, their insurance department, they were late to licensing. They didn't license till, I believe, 95. And I remember when Hurricane Celia hit in 1970, my father was with a group of public adjusters that had to sue the state bar. The state bar sued them that it was the unauthorized practice of law, and they won. They got the right to work, and that paved the way for licensing. But I digress. About 8 or 9 years ago, there was a roofing company in Texas that was practicing public adjusting. Again, this is an example of UPPA. The case was Lon Smith versus, I can't remember who, it was Reyels, Reyelts. So the federal court in that case granted summary judgment for the homeowner who was trying to get out of the contract, because they said, this is a public adjuster contract, you have to be licensed. The Texas department, and until Stonewater, the Texas courts, have been the best department in recognizing who we are, what we do, and our right to work. The Lon Smith case went up to the Fifth Circuit United States Court of Appeals, and I on behalf of NAPIA, wrote an amicus brief, and who was our local counsel who filed that brief for us? Steve Badger. A lot of people don't know that. And
yes, I was on a brief for NAPIA. Yes,
yeah,
absolutely.
So the problem with Stonewater, though, is, so the roofers in Texas figured out, we can't skin the cat this way, so what we're going to do now is we're going to invent an argument out of whole cloth that this is somehow violative of our First Amendment rights, that the public adjuster licensing statute curbs our ability to speak, curbs our ability to negotiate with an insurance company, curbs our ability to advertise that we will deal with your insurance company. And it is completely erroneous legal argument. The concern that I have is that I still think, in looking at the oral arguments, I don't know that the judges really understand who we are, what we do. I don't know that the TDI in this case really understood who we are and what we do. But I'm hoping that the court does see it properly, because what happened in Stonewater was they got dismissed out of the trial level, but then the intermediate appellate court reversed it and said they didn't say that it was a First Amendment violation, but they said you need to get facts on this. So they did remand it. But I think it's a good sign the Supreme Court took it before it even got that far. But Steve is quite right that if Stonewater is ruled the wrong way by the highest court of the state of Texas, not only will it gut public adjuster licensing in Texas, but it will give these roofers oxygen to advance this argument in other states, and it could create a tremendous amount of angst and havoc for you all.
And the last area where you are under attack involves roofing. Yeah, go ahead, Lisa.
Can you come up to the microphone, please? I'm sorry. So people can hear.
Your legislature meets every 2 years?
Every 2 years. We'll be meeting again in January of 2025.
So were you anticipating the worst and hoping for the best? I mean, have you queued up some legislators to try to reverse a wrong decision in that case?
Yeah, we'll see what happens now with the court. Certainly, we're hoping to see an opinion in the first quarter of 24. So if we see an opinion that gives us concern, then I think absolutely we will do what we've done in the past. NAPIA, TAPIA, and the insurance trade groups will work cooperatively to address this issue for our mutual benefit through legislative change. And that's one of the cool things that I want to emphasize. We've done this in Texas repeatedly. When there has been an issue of concern that affects the industry, we've worked together. And that's been really cool, and we will absolutely do that here.
And last thing, you know, as a former regulator, the regulators have broad authority in certain ways, and I'm sure you've researched every word in that code that could at least tame some of that before you could reverse a negative decision out of the Supreme Court legislatively. And I'm happy to work with you on that.
Yeah, absolutely. This is Lisa Miller. She's an insurance industry side person out of Florida, and you will see her today on the panel after lunch regarding appraisal, correct? Yeah, great. Thank you, Lisa. So the roofing contractor attack is not just in this regard. So I go to a lot of roofing conferences, Win the Storm and all the others, and I get up there and I either debate someone or I talk about issues. And what I find really interesting is that out in the audience, when I used to go, it was all public adjusters marketing to the contractors. But who's there now? Policyholder attorneys. Because what have they realized? Right, if the policyholder attorney can get the contractor to hire them, who gets cut out? There's no need for you. All right, there's no need. So you are under attack, and I fully believe this, by certain policyholder attorneys. All right, and the biggest way that you're under attack from these policyholder attorneys is from first notice of loss lawyers. Anyone see this in their states? You're fighting with lawyers for business. They are marketing to the insureds, hey, don't go hire a PA. I'm a lawyer. I will handle your claim for 10% also. And we see this. These are the door flyer. Call us before you call your insurance company. And you know who the other law firms are that are doing this. All right, there are a couple of lawyers who would believe that it would be preferable not to have PAs and just have lawyers do this at a reduced contingency fee. And you are fighting with them. They are a very powerful lobby themselves. So if any of these other attacks on your industry start to gain footing, the trial lawyer bar is very powerful at the legislatures. So I would encourage you, and I'm just going to say this bluntly, if any of the lawyers, policyholder attorneys in the room here, you should go up to them and make sure they are with you. Chip Merlin is with you. I've noticed this in the past 6 months. Chip has focused his blog big time on public adjuster issues. And I don't know if it's been intentional or what's happened, but I've sensed that. I get up every morning and read it. I joke about the 3 things I do in the morning, right? I get up, I get my cup of coffee, I go to the bathroom, and while in the bathroom, I read Chip's blog. All right? I think I told everyone in London that. Okay, I do it every morning. That's my routine because I learn so much, and I've seen Chip's emphasis on you. So make sure whatever lawyers you're working with support you, because I believe there is a segment of the trial lawyer bar, the policyholder attorney bar, who are out to attack you more so than my industry. And finally, you're under attack from within. How many of you see all these blurbs in the press, right? I see them, and my industry sees them. And it's really easy to complain about public adjusters from the insurance industry perspective when every month there's another headline about a public adjuster ripping people off. All right, now I know insurance companies rip people off too. We'll talk about that later, okay? But this is a problem for you because it gives those who are anti-public adjuster a voice to say, look at this. I pulled this yesterday. It took me 5 minutes just to pull 4 recent press articles. So it brings to the issue of the public adjusting profession. And I know Brian wants to give you a 2-minute speech about the importance of public adjusting as a profession.
So, I think it's very important. This kind of got glossed over. By the way, this is a picture of the first NAPIA meeting, and those are the NAPIA founding fathers. It's not the cast of The Sopranos. And my grandfather's in that picture, my dad's in that picture, and Paul Cordish is in that picture. Paul Cordish was my predecessor general counsel, and it's amazing that NAPIA has been around for 75 years and has had 2 lawyers in that whole time. Pretty remarkable. But anyway, in terms of the professional aspect of this, it was very important to my grandfather that public adjusting did start to be recognized as a profession. And Steve mentioned in terms of the Stonewater case that our amicus brief was filed jointly with the Coalition Against Insurance Fraud. There's an amazing story there. We joined CAIF 10 years ago. And at the first meeting of CAIF, one of their board members came up to me and said, "You're from NAPIA, what are you guys doing here? You're the ones that cause all the problems." And, how do you respond to that? So thank you for inviting us to join your association. Now, we are, when issues relating to these attacks from within, relating to public adjuster fraud come up, the first thing I do is I contact my colleagues at CAIF and say, here's the issue we're confronting. What do you all think about this? And 9 times out of 10, they're in lockstep with us in what our position is. And frankly, filing that joint brief with us in Stonewater would never have happened 10 years ago. So they're in lockstep with us on that. They're in lockstep with us on the issue of the anti-public adjuster endorsement. Their executive director, who's retiring, said to me when I told him about this thing that's going on with the anti-public adjuster endorsement, he not only said that they're in lockstep with us in terms of our position on it, but that he gave me ideas. He's, like Steve, was by history a coverage lawyer for first-party claims. Gave me ideas as to how we can attack it. And we now, this is not common knowledge, but their annual meeting is this Friday, we now will be sitting on their board. We have a seat on the board of directors of CAIF. So that's really important. It's really important that we remain a profession, that we stay with our strict guidelines of ethics, and that way we are able to at least mobilize and fight back very quickly on these headlines that come out, pillaring us, putting us in bed with what I call the bad actors.
So here's the problem. Is public adjusting still a profession? You all believe it is, don't you? Because you're here. You are professionals. Look at what's happened in my state. Back in 2004, there were 77 public adjusters. Jim Beneke, Art Jansen, and a couple of their family members and friends, right? That was pretty much it, right? And then it got to 2019, we're at 975. Since then, look at where we are now. 1,734 public adjusters in the state of Texas. So in less than 20 years, it's gone from 77 to 1,734. How many of you are licensed public adjusters in Texas? Raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 30. Where are the 1,704 other public adjusters who are not here? How many show up at the Texas TAPIA meetings? Where are they? Total licensed public, people with a Texas license. Yeah, and the concern is there's so many people out there trolling for cases. They're not you. I see these guys. Now, the stuff that crosses my desk every day, as Chip alluded to, is the worst. And it's really bad. I got one this past week where a roofing contractor conspired with a public adjuster out of Florida. He got his Texas license, and then the Florida public adjuster allowed the contractor to ghost adjust claims under the Florida PA's license. Things of that nature. I got another one, so it's nonstop. So when I say you're under attack from within, it ain't you. All right? It's those that don't view this as a profession. Right? It's not those who, like you, who know policies and know how to quantify and know how to write a good estimate. It's those that are just there to make money. And that is an attack on your industry from within, and I encourage you to consider something really hard. Is it too easy to become a public adjuster? You're all licensed. You all have a license already. Right? You're in. You're part of the team. And there's a statute out there, right, that says what it takes to become a public adjuster. But is it time to raise the bar in your industry, in your profession? You are essentially lawyers. Right? You enjoy a carve-out that allows you to practice law without a law license. And lawyers come to me and say, Badger, they should be doing more. They should have higher standards. So I tossed this LinkedIn post out there. And I had a meeting with Aldrich and some others, and we talked about these issues. And I would encourage you, for your profession, to have a dialogue with my side, if you want, to work together to raise the bar. If we change the Model Act, or even when we began with legislation in Texas to make it harder to become a PA, address some of these issues we're seeing with anybody who can get a license, and preserve your profession.
Excuse me, can I
Yeah.
retort? This is like that point, counterpoint. I'm going to give Steve a little bit of a pushback. We don't agree on everything. So the notion that Steve said, well, there's a carve-out, you really are lawyers, but there's a carve-out for you. No, you're not. Okay, and there's a plethora of case law on this. The two leading cases are Utah State Bar versus Summerhays and Hayden, and Linder versus Insurance Claim Consultants. And it's very clear that what you all do under the law is you handle first-party claims, you're measuring damages, and you're negotiating with an insurance company. That is not the practice of law.
Wait a minute. Prior to the enactment of the Texas Public Adjusting Licensing Statute, you had public adjusters being charged with the unauthorized practice of law.
I know. Well, let me finish.
Okay.
Maybe I'll give it. Okay. The distinction is, now 2 states allow third-party work. We do not agree with that, and that's one of the reasons the model bill's definition of public adjusters is only working on first-party claims. The third-party work is the unauthorized practice of law because in third-party work, the theory is under these cases, you are assessing rights and liabilities, and that's legal practice. I can't speak to what happened in prosecutions back in Texas and before licensing or even after licensing as to what was done. But that is the bright line distinction. And unfortunately, in Arkansas and Alabama, they are still holding on to this rubric that first-party property adjustment is the unauthorized practice of law, and it's dead wrong. And quite frankly, to hear lawyers still say that, well, there's a carve-out and you really are practicing law, you're not. But you can't overstep. You can't move on from a first-party case to a third-party case. You're not supposed to interpret policies and coverages. I know you all do it. And frankly, you're better than most lawyers, but you're not supposed to do that. And the minute there's a coverage question, obviously, everybody I know in this room, when it's a coverage question, they always tell their clients, the insured, you got to get a lawyer. We can't litigate. We can't handle those questions. So I just take some exception to the way you couch that.
Fair enough. Yep.
So near and dear to my heart, I agree with you 100% on raising the bar. I think we should open the Model Act. I do think we need to raise the bar for public adjusters because I think, just as you said, it will improve the industry for everybody. So I'm all for that. And I don't think it needs to be like a quid pro quo, so to speak, but I am wondering, question is, what's your perspective, and is there anything being done from the carrier side? Because in my primary state of New York, independent adjusters don't have to get continuing education. So, here we are saying we need to raise the bar to improve the industry by raising the bar for public adjusters, but there doesn't seem to be a real push for the IAs, and I'm wondering what your perspective is on that.
So when you speak a lot to groups, you kind of know what's going to come up. Right? You kind of know, okay, well, Badger, what about your side? Yes, all right, insurance adjuster training also is an issue. I agree. All right, I think it's more of an issue in the residential lines where they're throwing out the newbies who have just spent a $349 amount of money to go to a 40-hour course, and they throw them out in the field. I get it. Okay, I understand the issues. There is discussion in the insurance industry about the talent drain, right, and how to attract professionals into the insurance business. I understand it's an issue on my side as well. I get it, right? And my clients are mostly commercial, where my clients mostly have more experienced adjusters who have been around a while. Not all of them, I understand that, not all companies, but yes, all right, I'm mindful of it. I talk to my clients about it. I try to influence the industry on the issue, but I think most of the problem is with the big residential insurers who I don't represent, yeah, and what they're doing and how they're handling things. So you bet, it's a legitimate issue. I hear complaints all the time. Unfortunately, on my side, when there is a person like that who's no good, there is or actually I should say fortunately for the insured, when there's someone on my side who's no good and they screw up a claim, there's accountability to who? The insurance company, right? They're going to get sued by Chip or someone for bad faith for sending out a crappy adjuster. The problem on your side is that when there's a crappy public adjuster, there's no one else accountable. That person is representing that homeowner with no one above them who can be held responsible for the screw-ups. It's that new licensed PA who just sucks, who's screwing over the homeowner. All right, so let's have a dialogue about raising the bar.
Steve Harvey's got a question.
I spent a lot of time talking about things that could be done. And if you don't like any of them, send me an email. I'll give you my email address at the end. Let's talk about what we all can agree upon. Yeah.
I love them all.
Yeah.
But I'm not sure it'll solve the problem. I'll get my question mark. I heard what you said. Because you have you got 1,700 people in Texas today, and I think I was one of the original 77 in 2004 who haven't met this requirement, and you're going to grandfather them in. I understand it'll take a while. My question is this. The whole issue that's going on in Texas in the courts, we end up handling claims, and there's professional fees coverage. It excludes, as Brian used the analogy that we bantered back and forth for years, the doctor or the dentist, okay? But some of the brightest minds that have ever sat in this room have given up their public adjuster's license, and now they call themselves consultants, okay? Or there's people that have never been in these rooms that call themselves consultants. They not only can handle these claims, but they're getting their fees reimbursed. What is your thought on that?
Yeah, so there is a gray area, and Jim Beneke and I have debated this over the years, of the claim consultants who work for brokers. All right, and I think that's mostly what you're referring to as a claim consultant who works for a broker who is... Well, so if it's not someone working for a broker and they're out there... Okay, if they're working on behalf of the...
just, there's some consulting firms that's what they're doing.
Then turn them into me, they're engaged in UPA. Right? That's my view.
Your clients, I believe, are paying their fees on a regular basis, and they're pushing back when we ask for the same fees. Okay?
Yeah,
and I've seen the fees coverage as high as $5 million on some of these policies.
If they are negotiating a claim on behalf of the policyholder, they're not a construction consultant or something of that nature. They're just negotiating the claim. Right? That's the practice of public adjusting, in my view. So if one of my clients is paying that, and they're just negotiating the claim, and it's not a broker person, then I'd be interested in knowing about that. Because Steve Badger's personal view is that is the unauthorized practice of public adjusting. I agree with that. Okay? I agree. Lisa?
Direct or indirect to cover the loss consultant from a licensing standpoint.
Okay.
So if you're indirect, which is pretty broad, if you're indirectly doing the things and activities you're talking about, you got to have a license.
Yeah.
Maybe that's the solution.
So there's a legislative fix for that issue that they had in Florida. So I support you on that issue. The brokers are a tough one because they are advocating for the insured in the process, the entire insurance process. But otherwise, no, that's a concerning issue. I agree. All right, let's keep moving along. What's next? Let's see. We've talked about that. All right, let's talk about fraud. All right, we can talk about insurer fraud. We can talk about insured fraud. We could just go on and talk about fraud. You can tell me all about the Florida guys who's been paraded around, and I can talk about Drew Aga, and I can talk about McClenny Mosley. Has everybody filed the McClenny Mosley saga? All right, it's not a public adjuster problem, but it's a problem for your side of the industry, not just because of what the lawyers did, but because of what the contractors did, and the litigation funders, and the solicitors. Google McClenny Mosley, Louisiana, and you're going to see what my industry is dealing with, the breadth of the dash for money through manipulation of the process. And that's why you're all being affected by these grand schemes to extract as much money as possible out of the insurance industry. And it's not just the normal people. Now we're seeing all these litigation financiers jumping in, who's a huge part of the McClenny Mosley story. And that's a big issue that we're dealing with. So we could keep talking about fraud. Again, insurer fraud, insured fraud. You know, I fully support Doug Quinn and the American Policyholder Association, as I hope you fully support the Coalition Against Insurance Fraud from my side. Can we just agree that fraud is wrong? All right. It's a word that we have to be careful about using, and Brian and I had a good discussion about this yesterday. Why don't you talk about your concerns about throwing around the fraud word?
One of the things that is a problem is that oftentimes we hear that public adjusters inflate claims. Public adjusters, and that's fraud. Just because your numbers are higher, oftentimes significantly higher than a carrier's numbers, doesn't mean that you're perpetuating insurance fraud. However, what everybody in this room needs to understand, and I'm probably preaching to the choir, I should really be talking to the 1,650 other public adjusters in Texas, or the 8 million of them in Florida, whatever. The insured who you represent has the absolute burden. The insured is no different than a plaintiff in a civil lawsuit, has the burden to prove his or her damages. And when you sign that insured to a contract, you assume that burden on their behalf. And proving those damages is not submitting a number of $1 million to an insurance company when you know the real damages are $730. Okay? So if you're going to submit any claim, but particularly when the claim is significantly higher, I mean, you wouldn't be hired if the damages were not in dispute in many cases. You have to support your damages. If you have a $3 million business interruption claim, make sure you've got the backup from a CPA or somebody who's an experienced business interruption calculator to support that. The insurance company may come back with a different number from another CPA, but that gets into the battle of the experts. That's what happens in these cases. That's what happens in many appraisals. Mr. Held and I were together a few months ago on an issue just like that. But you have the burden. So in order to insulate yourself, and nobody in this room wants to encourage or support any kind of fraud, make sure before you submit a claim it's supported by the evidence, it's got backup documentation, and it is appropriate and can be defended if you do end up at the appraisal table or in court and you're an expert witness.
So I could talk all about, well, Larry, that's right. Let me talk about my one rant issue first. And I think this is a very hot topic. I've considered this the dirty little secret that we've all gone along and gotten along with over the years. But because of the abuses we're dealing with, a lot of carriers are now paying attention to it. It involves, how are your commissions paid? Where does your 10% commission, or whatever it is, come from? Do you tell your clients at the beginning that, hey, you're going to have to go out of pocket for my commission if you're going to replace all your damage? Do you tell them that? Or do you tell them, as Noble tells people, Our fee comes out of the insurance proceeds at the end. Google AI. I just typed in the words up above. Public adjuster fee come from claim proceeds. And look what Google AI says. Yes, public adjusters are paid from the claim proceeds. Are you paid from the claim proceeds? Do you tell your people that? Let's use a very simple hypothetical. $2 million roof claim. You collect 1.5 ACV, $100,000 deductible, the roof's all done, and you turn in that $2 million contract with the roofer or the $2 million estimate and say we're all done. How do you get paid in that scenario? You don't. By your client, out of pocket. Does your client have $200,000 to pay you? Is that what's really happening? Because in the past few months, I've uncovered a number of public adjuster double invoice kickback schemes. And we're paying attention to this, guys. And someone last night out in the hallway, and I won't say who, and we had this discussion, a PA said to me, Badge, this does go on a lot. And it does, and I think we all have to agree that's insurance fraud. Because if you tell me it's a $2 million roof in order to get your RCV holdback, and you only incurred 1.8 because you got a backroom deal with the roofer, all right, that's a problem. And at some point, some former employee is going to get pissed off at you and send me all your documents to show me you're doing this. Okay? So be careful. That's my only rant of the day.
Hang on, please.
All right, go ahead.
I'm going to be heard. And, I want to channel Marissa Tomei in that scene in My Cousin Vinny. When she looks at everything, she's been qualified as an expert, and she goes, I'll just channel her. No, Mr. Badger is wrong. Okay, when I go and talk to regulators, one of the questions that I always hear from them is, well, if your clients are charging 10%, how can an insured ever be made whole? And there are a myriad of answers to that question. But I think the most common answer to that question is, that I give, look, if insurance companies were fully and fairly paying claims, my clients couldn't make a living. And sometimes it's worth it to an insured to pay 8 or 10% or whatever the number is to make sure that their claim is properly presented and they're fully indemnified, which after all is the carrier's obligation. Now, Steve is saying that that's insurance fraud if somehow you have to go back to the roofer and say, look, this is all the guy's got. I don't agree with that. If it's a systemic problem, you're doing it on every loss, maybe your point has more credibility, but I don't think that in and of itself is insurance fraud. I could turn the argument around and said, look, if you're offering $500,000 on a claim that's really worth $2 million or $1.8 million, and that's so egregiously low, you guys are committing insurance fraud. I think we got to get all these fraud words out of the conversation all the time. But again, that goes back to my original point. In terms of your damages, make sure you can support them. That is so critical.
So, man. All right, well, we'll just move on. I will just say this briefly. If you tell me it's a $2 million RCV to get holdback, and you got a backroom deal with the contractor to do the roof for 1.8, all right, I got a pretty good argument that that's insurance fraud. All right, and I acknowledge, all right, that you're all here because insurance companies often have a disagreement with you and your client as to what the right measure is. All right, and I throw the fraud word around very, very rarely. I filed 2 lawsuits for fraud in my entire career. All right, and so we need to be careful about fraud and accusing it too often. So lots of issues with low ball and inflated claims. We should move on because we're moving kind of slowly here. Creates a lot of problems. We should all work to get the fair value. I could go over this whole hypothetical, but I'm just going to tell you my 2 things you should do, and I say this in every presentation of what needs to be done. I'll skip all this, is let's stop playing the Xactimate game. All right? I hate the Xactimate game. Can we all agree? All right? It's a problem. Xactimate was designed to give the insurance company a way to come up with an initial measure to get some ACV money out. All right? It's not intended to be the final determining measure of the final claim. What's the measure of the final claim? What is it? the cost actually incurred. And what determines the cost actually incurred? How much you paid the contractor, right? Whoever did the work. So let's get out of the Xactimate world after the initial measure, and let's get into the real bid world. And when my clients now are asking you for the contracts and the documents, give them a reason to pay. All right? This is what Brian said. Give them a reason to pay. The real number that it cost. Don't just sit there and keep barking about your Xactimate estimate. All right? Because the carriers now, because of all the abuses they've dealt with, all right, are now realizing, no, I can go dig for the cost actually incurred. Tell me what that is. That's my biggest piece of advice to you. Give the carrier a reason to pay, supported by real invoice and bid documents.
Uh-oh, we got a question from Bobby Levin. This ought to spice things up.
I'm going to take the mic and I'm going to walk around. You just mentioned the word incurred. So I think one of the problems, certainly the way the problems that we encounter is that, where you have a substantial amount of depreciation. Let's say you've got a major claim, you've got $1 million worth of depreciation. The insurance companies will say, well, incur all the costs, pay it, and then we'll reimburse you and pay it.
Yeah.
So I'd like what your opinion is of the difference between spent and incurred.
Yeah, so I understand the argument, and there is some case law to support the position that an actual contract is sufficient to be incurred. And that helps the building owner. Okay, they don't have the money to write the check for that $800,000 and then get the holdback back. Right? I understand that, and I'm mindful of that. But, again, the abuses drive the law. Because of a radical abuse in that regard, where an insurance company was given a $2.4 million contract for a roof that really only cost $800,000, a court held that the insurance company's RCV obligation is determined upon not what the contract was, but what the subcontractor was paid to put on the roof. And that's why you're all getting asked now for subcontractor invoices. So my clients, all right, have the right not to pay on just the contract and dig deeper. But with that said, right, if I have no reason to suspect any tomfoolery, I will tell my clients, look, they don't have any basis to pay this. It's all legitimate as long as the work is done. The contractor needs to be paid. That's the other thing. If the work is done, the insurance company is in a real hole. Okay? The work is done. You got invoices showing what it cost. How do they not pay at that point? I'm with you on that. And they provide proof that the deductible was paid. All right, you got to come up here. That's the rule I was given. I'm sorry.
Yeah, with the shirt on.
So, do you believe in line item depreciation recovery, or do you believe the estimates in totality?
Oh, man, that's a hard question. I'll give you the lawyer answer. It depends. It really does. Okay, I understand. Here, let's go back, and that tees up this other issue. How do you take your commission out of the claim proceeds? Well, you collect the ACV on a couple of line items that really aren't that damaged, like the fence or the trampoline or whatever, and you tell the insured, don't fix that, and you can pay me with those items or those line items. I get that. That's okay. All right? That's the way around that issue. All right? That's absolutely fine, but that's a complicated issue, and I appreciate you asking it. So, all right, let's get to appraisal. So here's what appraisal was intended to be. Can we all agree? Amicable, prompt, like right after the dispute arose, independent, to resolve claims where coverage was undisputed and we're just fighting about the cost of repair. So what would happen in the old days? There'd be an appraisal. You'd get John Held on one side, you'd get Art Jansen on the other, and they agree upon somebody, and they go down to Bob's Steakhouse and have a couple bottles of wine, and they worked it out. Right, John, isn't that how appraisal used to be? Yeah, whiskey, okay, whiskey. But that's how it worked. What is it now? Right, fair enough, everybody agree? What's happened? We could spend an hour on appraisal. And what is it today? Non-judicial, no court supervision, no rules of procedure, no ethical guidelines. We got appraisal professionals now All right, they're getting taught in the other room by Bob, and I fully support education, fully support what Bob does, what John Robeson does, what Wynn does. We should have more of that. But it's a mess.
Excuse me.
Of course.
So let's get back to my original point. Okay? When Steve talks about no judicial supervision, historically, there was never a need for any of that because it was so rare. It wasn't invoked much, and there was never an issue finding people to be appraisers who didn't do it for a living. There was no problem finding an umpire with some experience in first-party property because it just didn't happen often. You didn't need all of this judicial. Now, I mean, I must get 5 appraisal opinions from appellate courts on my desk every month. And it never used to be that way. Sorry.
No, I agree, it is. So here it raises the question, why is there so much more use of the appraisal process today? Go ahead.
Correct.
A lot of adjusters don't know how to, you're talking about public adjusters, right? Oh, my side. Oh, okay.
It's true on both sides.
It's true on both sides.
It really is.
Other reasons. Why are there more appraisals today? Contractors, we'll talk about that. John? Yeah, length of time it takes between data loss and settlement. Long, delay, frustration, dump in an appraisal. The art of adjusting has been lost. Can we agree in large part on both sides? Yep. All right, with a lot of people, with the 1,650 not here and a lot of independent adjusters, I get it. Yeah, and I also will admit that adjusters do not have the field authority they used to have. Yeah, I understand that. I recognize that, and we could have a long evening drinking whiskey debating about why that is. Yeah, so that's an issue. Here's the other reason, I believe. Because the courts have expanded the scope of appraisal to include causation issues such as the extent and existence of damage. Whereas in the past, appraisal was generally, and Chip and I have debated this issue, but generally more limited to pure quantum disputes. And now we got appraisers arguing about whether the roof is damaged, when it occurred, should GCO&P be included, do dents equal damage? All these issues are now basically getting adjusted in the appraisal process.
But one of the problems, though, is, and we can agree or disagree on whether or not that's appropriate. The case law goes all over the place.
It does.
And I think it's frankly appropriate that scope is subject to appraisal. But what happens is, and this one I'm going to put on your side, okay? As soon as there are problems, all of a sudden, insurance companies say, oh, wait a minute, there's a coverage problem here. And suddenly then, the courts get clogged with cases that should never be in court because appraisal can't deal with coverage.
I agree with that, and we're going to preserve all these issues for them to talk about this afternoon. And I just want to tee up a couple of things now. Amy Bach reached out to me about a month ago, or a couple of weeks ago, and said, hey, Badger, it's time for us to meet and have a discussion. Everybody wants to talk about appraisal. Chris Aldrich and some others, we met about a month ago to talk about issues in Dallas, and we talked about appraisal. And we're going to try to bring both sides together early next year for a summit, for a discussion about what we can do to fix, to improve the appraisal process. And in advance of that discussion, I wanted to get a dialogue going. So I put 2 LinkedIn posts out. The first was a post about what I call a statutory appraisal process. Oh man, did that create a lot of discussion. All right? I view it as a positive thing. It's a way to resolve small disputes through a statutorily created appraisal process for disputes where the total amount is $75,000 or less. All right? Then I also put out there an appraisal provision that I wrote. And it's actually, it is what we're recommending to our clients as an appraisal process that fixes all the known abuses. All right? That created a ton of discussion also. But I wanted to have that discussion so we can start thinking about the issues in advance of getting together next year.
Excuse me.
I knew there'd be people who wouldn't agree with all of it.
Yeah, and I'm one of them. And I'm up here with you, so,
yeah.
you know, and I got a microphone, so there you go. One of the ways Steve talks about attacks from within, but this is an attack on the profession that is just It's just the way it is. When insurers put appraisal clauses in their policies, what does an insured have to say about it? Nothing. Okay? So you're going to be stuck with whatever language the insurer puts in the policy. The appraisal language used to be pretty standard. It was the same clause in every policy. Now, there are all kinds of different languages. And the problem with Steve's proposed language, and I don't want to go A to Z through it, but if it's put in, the insured's going to be stuck with it unless and until a time when that insured has a loss, and then when if somebody needs to demand appraisal, then you're going to be stuck with the carrier rules because they write the policy. It's called a contract of adhesion, meaning one side drafted it, the other side had no input into it. We can never, we being policyholders and public adjusters and policyholder attorneys, we can never do anything to change that. It's a reality, but you're in a much less advantageous position on this issue than the other side.
So I would encourage you, Brian, to read the provision and outline, as another lawyer here did for me, outline what you believe in my clause is unfair to the insured.
Okay.
Tell me that. Because if you believe it's unfair to the insured, I want you to tell me that, and we'll address it. Because my intent was to fix the abuses, but not change the process. Okay? So let's have a dialogue about that.
Well, I'm coming to the meeting, so I'll be ready,
You'll be in the meeting.
Armed there.
Okay, let's, 2 more issues, and we'll be done. We need to talk about what's coming, and I alluded to it before. Managed repair, preferred contractor programs. All right? What do they really look like? There's basically 3 types. It's the original program that you all hate, right? Mad Sky and Crawford Connection. Okay, I get it. All right, I was in a meeting with a client about 8 years ago, and one of these guys pitched my client. At the end of it, I told my client not to do it. All right, but there's other programs that are coming. There's preferred contractor programs, and there's a right to repair issue. I would encourage you to talk to the art guys who are here. All right, raise your hands. The art guys are here. These are quality contractors who are trying to find a way to improve the process. I guess they're out by their booth waiting for you to come see them after. All right, they've got a booth here, and they've got a preferred contractor program that I believe a carrier could put into their policy, and it's fair to all involved parties. And I'm happy to talk about it, but that's coming.
I would like to talk about it now. So the analogy that I would draw here to these managed, and I see them all the time in my state, these managed repair, preferred vendor contracts. It's a very pretty way of saying, we're going to take care of you, and we're going to ignore the inherent conflict of interest that exists. It's much like UPPA. One of the reasons that contractors should not and cannot be public adjusters is there's an inherent conflict of interest when you're doing the work and also preparing all the estimates and negotiating with the insurance company. Similarly, if there are preferred vendors who are getting $8 million of business a year from State Farm or whatever it is, you think that you're going to get the best independent bang for your buck. Never. There you go. So there's an inherent conflict of interest. Of all the things we've talked about today, on behalf of the public adjusting profession, I think this is the issue that I have the most problem with that insurance carriers are promulgating.
Yeah, well, I would encourage you to talk to these guys about what the ART program looks like, because it's not Mad Sky, it's not Crawford Connection, it's not managed repair. It's a preferred contractor program. And under this program, the contractor can charge whatever it believes is appropriate.
Yeah.
Right? They charge whatever it believes is appropriate. All right? And so look into it. There's efforts to try to find a program that provides the right balance. Otherwise, what are you going to get? You're either going to get managed repair, which I agree I'm not excited about, or you're going to get this. And you ain't going to like this. And this is coming. This is a letter I wrote for a client just a month ago. All right, and it's a long letter, and it laid out what they are doing now in the Dallas-Fort Worth area. For every single claim where they've agreed to buy the roof, they are going to invoke their right to repair and send a contractor out to fix the damage. And they have the right to do that, don't they? It's in all the policies. And they have been loath to invoke the right to repair. But carriers have decided that the risk of invoking the right to repair and having a contractor screw up and the insurance company owning the roof is a far more manageable risk than dealing with all the abuses they're having to deal with, particularly now in the claim process, dealing with everything getting dumped in appraisal. All right, so it's coming. And so I would encourage you to keep an open mind for programs that are preferred contractor programs that I believe strike the right balance.
Wait, Kenny's coming up with a question.
Under a right to repair contract, and you exercise it, or the carrier does that mean that they now buy into any required code upgrades on that roof?
Well, it depends upon, of course, whether there's code upgrade coverage.
Assuming there isn't code upgrade.
In residential matters, what I tell the clients is that you are required to provide the insured with a roof that meets both manufacturer and code requirements. So, yeah, I will tell them, all right? So you have to give them a code-compliant roof. Otherwise, what are you giving them? Yeah, I agree with that. Now, code upgrade issues, when you get in commercial losses and other issues, I agree are complicated. But I'm telling them you have to give them a roof that complies with manufacturer specs and code requirements in the general residential context. Yeah.
So People's Trust has started suing their clients for doing mitigation repairs. So how does the mitigation responsibility on the policyholder side match up with the right to repair?
Yeah, so it depends upon what the carrier is invoking, doesn't it? Yeah, and so it is a more difficult endeavor when you're dealing with a water loss claim or you're dealing with fire damage. So where I'm seeing it invoked now is in the simple claim context where you just got wind or hail damage to a roof. Right? And it's just a matter of what it costs to replace that roof, and there's so much fighting about that now. The carriers say at a single trade roof, let's just get somebody out there and fix it. I acknowledge it's a different story when you've got interior damage, and what this carrier is doing, they're invoking it just for the roof, and if there's interior damage, they will adjust that and pay that. And yeah, they're splitting it, and kind of what you're talking about, and that's a tough situation. All right, so on that gloomy note, let's finish with another gloomy note, UPA. So as Brian said, Texas has worked very hard to address UPA issues. This is an area we've worked very well, working with Tapia and Napia on these issues. In fact, about 15 years ago when this first became an issue, Tapia hired me to write letters to every contractor who they knew was doing this. And I'd write a letter on behalf of Tapia to a contractor saying, don't do this. So we've made some progress on the issue. The Lon Smith class action is still pending for their UPA violations long ago. And as I said, I go after contractors all the time for this. And they ain't very happy. All right, old Eddie Rickert told me that he's going to tie me up, douse me with benzene, throw a cigarette at me, and light me on fire. All right? But I feel strongly about this issue for your industry and for mine. Contractors should not be negotiating claims. Unfortunately, yesterday when I threw this together, I just typed in contractor negotiate insurance claim, and boom, it's still there. They're still doing it, so we have to continue to fight this issue and keep these guys out of the process. Brian and I play a perpetual game of whack-a-mole, all right, and we're just going to keep doing this. All right? And we have the same objective here. All right? Now, I anticipated this question. Badger, why do your clients allow this to happen? All right? You're complicit in negotiating with contractors. All right? I acknowledge that there is a gray area, right, where we have to try to do the best thing for the insured. Okay, if the contractor's doing the right thing, when I speak to contractors, I put up a big smiley face and say, be nice. Okay, if we're kind of living in that gray area for the benefit of the policyholder and stuff's getting done, yeah, we do that. We allow it. Okay, but what we don't allow the ones who are sending us letters threatening bad faith and all of that. So there is a gray area. I understand it. I would not say we're complicit.
Well, and also, one of the major area in which the new NAIC Model Act augments and improves the existing Model Act is that there's now an entire section on UPA and forbidding it and making it a crime. And we didn't have that because it wasn't a problem in 2005. So that, now you say, well, that's just a Model Act. Yeah, but the Model Act that was promulgated and passed in 2005 has now been passed in over 20 states. So I don't think it's going to take long for this to grow. And certain states have already incorporated some provisions like this in their statute, like Rhode Island and Delaware and a few others.
Good. All right. I think that's it. We're going to finish with 2 minutes on Brian's thoughts about the future, and then 1 minute on mine.
Okay. Well, I think it's an encouraging sign that this conference in and of itself keeps growing. And it's a double-edged sword, because you could say it's an encouraging sign to see that and also to see so many more public adjusters in states like Texas and Florida, but that's really not an encouraging sign. So I quite agree. The one thing I agree with Steve on today more than anything else is, and I think NAPIA stands for this because Justin spoke about this too, we really should concentrate on public adjuster training, experience, and qualifications. If that means making the tests harder, if that means making the road to becoming a public adjuster more rigorous, so be it. You guys are all licensed already. You're in. We want to make sure people entering the industry are competent. One of the problems that we really have, though, is many of the regulators don't understand who we are or what we do. We were in a meeting a few months ago with a commissioner who shall remain nameless, very nice person. And at the end of the meeting, we was talking to him for an hour and a half. He shook Chris's hand and he said, "By the way, you guys do any work for insurance companies?" I'm like, what have we been talking about for the last hour and a half? So there's still a lot of ignorance on the part of government officials, regulators, judges, and legislators about who we are and what we do. And I think one of the things that we need to concentrate on is to continue to educate them on the profession of public adjusting.
Good. And I will say this. I am all about cooperation. I value the relationship that I have with TAPIA and with NAPIA. We have accomplished some really good things for the Texas insurance industry in addressing issues together. And that's why I believe these forums are so important. I'm going to put a bunch of shit on social media you ain't going to like. All right? I get it. But you're always going to see two things. One, you're going to see that I'm doing it to create dialogue. And number two, I'm doing it to help bolster the professional public adjuster. And I continue to always put that in there, the professional public adjuster, because I do believe there is a role for you. I want you to know that, and I want to work with you to address the issues that our collective industry has that is a detriment to the insured. We should work together to fix that.